So today, the Supreme Court of the United States issued a 9-0 unanimous decision that carries massive nationwide implications for the sanctity of your home and the limits of police authority. This isn't just another legal update. This is a case that every single American needs to understand, especially those who value their Fourth Amendment protections and the privacy of their own front door. We are talking about a ruling that clarifies exactly when the government can cross your threshold without a warrant, and it's a decision that will immediately shift how law enforcement operates in all 50 states. If you've been following the news, you know the Supreme Court has been tackling heavy hitters lately, but this specific ruling in Case versus Montana hits differently because it deals with the one place you are supposed to be the most secure, your home. And what makes this even more remarkable is that all 9 justices, conservative and liberal alike, agreed on this decision. In our current political climate, getting unanimous agreement on anything is noteworthy, and when it happens, it sends a seismic shock through the lower courts. Now, before we jump into this deep analysis, if you want to stay ahead of these critical legal shifts and support the mission of making complex law accessible, the best way to do that is simply to subscribe. Also, make sure to hit that notification bell because YouTube's algorithm doesn't always like sharing these types of high-stakes legal breakdowns unless you tell it to. We cover a lot of breaking legal news here, and these Supreme Court decisions can come down at any moment, so making sure you're notified really helps you stay on top of what's happening with your rights. For years, there has been a massive circuit split across the country. Different states had different rules. In some places, like the 9th or 1st Circuits, the standards for when police could enter your home for a welfare check or emergency aid were murky. Some lower courts were using a watered-down standard called reasonable suspicion, while others were trying to hold the line at probable cause. This created a patchwork of inconsistent constitutional protections depending on where you lived. If you lived in a state that followed the community caretaking doctrine, your home was significantly more vulnerable to warrantless entry than if you lived in a state that required a strict warrant for almost everything. Today, the Supreme Court ended that confusion. But the answer they gave is one that might surprise you, and frankly, it's one that should make every homeowner pay close attention. This case is critically important for several reasons. First, it establishes a nationwide standard that every state must follow. From Maine to Hawaii, from Alaska to Florida, the same constitutional standard now applies. Second, this case is particularly important for gun owners because it involves a situation where law enforcement entered a home based partly on concerns about firearms, and then ultimately that entry led to the discovery of a handgun and criminal charges. And third, this ruling impacts everyone because it defines the scope of what's called the emergency aid exception to the warrant requirement. To understand the nationwide implications, we have to look at the facts that forced the justices to act. The case involved a man named Trevor Case from Anaconda, Montana. One evening, Mr. Case's ex-girlfriend called the police with some concerning information. She told them that she had just gotten off the phone with Trevor, and during that conversation she said she got a bad feeling. She reported that she thought she heard something about a firearm, and she was worried that Trevor might harm himself or potentially harm police officers if they showed up at his residence. Now, this is important. The ex-girlfriend's report was somewhat vague. She didn't give police a clear, detailed account of specific threats. It was more of a general concern, a bad feeling based on this phone conversation. When police arrived, they brought the ex-girlfriend with them. When they got there and spoke with her in person, her story became even less specific. She told the officers that she couldn't really remember exactly what Trevor had said on the phone, but she maintained that she had this bad feeling and that she was concerned he might shoot himself or shoot the police officers who were responding. Here's another important fact. Apparently, all 4 of the police officers who responded to this call knew Mr. Case personally from prior interactions. They knew that he had a history of mental health issues, and they had dealt with him before in various situations. When these 4 officers arrived at the home, they didn't just immediately bust down the door. Instead, they tried to make contact through less invasive means first. They looked through the windows of the home, peering into different rooms to see if they could locate him or assess the situation. They could not see Mr. Case anywhere inside. However, one of the officers did notice some items that caught his attention. There was what appeared to be an empty handgun holster, and there was also a notepad visible inside the home. The officers then knocked on the doors multiple times. They shined their flashlights through the windows. They called out for Mr. Case, announcing their presence and trying to get him to come to the door or at least respond to them. But there was no response. Nothing. Complete silence from inside the home. Now, this went on for about 40 minutes. For 40 minutes, these police officers were outside this home, trying to make contact, trying to get any kind of response, trying to figure out what was going on inside. During this time, some of the officers were expressing concerns among themselves about what they should do. Some of them were worried about entering the house based on their prior interactions with Mr. Case and based on what the ex-girlfriend had told them about potential violence. But after those 40 minutes with no response, no signs of life, and with the information they had about potential self-harm or harm to officers, they made the decision to enter the home. They found that the front door was actually unlocked, and they went inside. When they entered, 2 of the police officers proceeded upstairs to check the upper level of the home. One officer entered an upstairs bedroom, and when he walked into that room, he saw a closet. As he approached the closet curtain suddenly jerked open, and there was Trevor Case, standing inside the closet. The officer said that when this happened, he saw what appeared to be a black object in Mr. Case's hand or near him. The officer, apparently startled or perceiving a threat, reacted quickly and fired his weapon. He shot Mr. Case in the arm, and the bullet passed through his arm and into his stomach. Mr. Case was wounded, and the officers then detained him and called for medical assistance. After this incident, the officers searched the bedroom and they found a handgun in a laundry basket that was in that same bedroom, close to where Mr. Case had been hiding in the closet. As a result of all of this, Trevor Case was charged with multiple criminal offenses, including assaulting a peace officer. But his defense attorneys raised a critical legal argument. They argued that the police officer's warrantless entry into his home violated the Fourth Amendment of the United States Constitution. And if that entry was unconstitutional, then everything that flowed from that entry, including the discovery of the handgun and any other evidence, should be suppressed and not allowed to be used against him in court. This is called the fruit of the poisonous tree doctrine. If the initial entry was unlawful, then the fruits of that unlawful entry can't be used as evidence. This argument was rejected by the trial court. Mr. Case was convicted. He then appealed to higher courts, and eventually his case made it to the Montana Supreme Court. The Montana Supreme Court issued a 4-3 decision against Mr. Case. It was a split decision, but the majority ruled that the officer's entry was lawful and therefore the evidence should not be suppressed. However, here's where things get really interesting from a legal standpoint. The Montana Supreme Court, in reaching its decision, did not apply the correct legal standard that the United States Supreme Court had previously established in earlier cases. There's a Supreme Court case called Brigham City versus Stewart that dealt with this exact type of situation, emergency aid exceptions to the warrant requirement. In that case, the U.S. Supreme Court said that the standard for these situations should be whether the officers had an objectively reasonable basis for their belief that someone inside needed emergency aid, but the Montana Supreme Court didn't use that standard. Instead, they appeared to use a lower standard called reasonable suspicion, and they also applied something called a community caretaking framework that was actually pretty watered down. They essentially made it easier for the government to justify warrantless entries than the U.S. Supreme Court's precedent would allow. The legal battle went all the way to the High Court, and the question was simple. Was that entry legal? The Montana Supreme Court said yes, using a very loose reasonable suspicion standard. Mr. Case argued that the police needed probable cause, the same high bar required for a criminal search. The U.S. Supreme Court had to decide which standard would apply to every police department in America. Because of this massive question with nationwide implications, the Supreme Court agreed to hear the case. They granted certiorari and held oral arguments where both sides presented their positions. In the unanimous ruling authored by Justice Elena Kagan, the Supreme Court rejected both extremes. They told Montana that reasonable suspicion was too weak of a standard for the home, but they also told Mr. Case that probable cause was too high for emergency aid situations. The Supreme Court held that police officers do not need probable cause to enter a home without a warrant when they are responding to a genuine emergency situation. Instead, the court reaffirmed the rule from Brigham City. Officers may enter a home if they have an objectively reasonable basis to believe that someone inside is seriously injured or facing imminent harm. Let's break down what this means because the specific standard matters a lot. The Supreme Court rejected 3 different positions in this case. First, they rejected Mr. Case's argument that probable cause should be required. Probable cause is the standard typically used when police are investigating crimes, but the Supreme Court said that probable cause doesn't fit well in emergency aid situations because these aren't criminal investigations. These are life-saving interventions. When officers are trying to save someone's life, requiring them to meet the probable cause standard would be too restrictive and could cost lives. Second, the Supreme Court rejected Montana's use of the reasonable suspicion standard. Justice Kagan took a sledgehammer to that logic. She explicitly stated that you cannot take a standard designed for a brief, minimally intrusive stop on a public sidewalk and apply it to the most private place on earth, the home. This is a win for the Fourth Amendment. By rejecting the watered-down Montana standard, the court has told every police department in America that a hunch or a bad feeling from a neighbor is no longer enough to kick in a door. They need objective facts. Third, they rejected this whole watered-down community caretaking approach that Montana had been using, which was even more permissive than reasonable suspicion. Instead, the Supreme Court landed on this middle ground, the objectively reasonable standard. Officers need an objectively reasonable basis to believe someone inside is seriously injured or imminently threatened with serious injury. This is evaluated from the perspective of a reasonable officer in the same circumstances, looking at all the facts available at that moment. Justice Kagan wrote that the Fourth Amendment does not require police to stand by and do nothing if they have an objectively reasonable belief that someone inside is seriously injured or imminently threatened. However, she also made it very clear, this is not an open-ended license for police to conduct a general search. The emergency aid exception does not give police officers free rein to search the premises beyond what is reasonably needed to deal with the emergency. Applying this standard to the facts of this case, the Supreme Court concluded that the officer's entry was constitutional. They pointed to several factors. The officers were responding to a credible report from the ex-girlfriend about potential self-harm and potential harm to officers. They heard that a firearm might be involved. They observed an empty holster when looking through the windows, which corroborated the report about a gun. They received absolutely no response from inside the home despite 40 minutes of trying to make contact. They knew Mr. Case had a history of mental health issues. Taking all of these facts together, the Supreme Court said a reasonable officer in that position would have an objectively reasonable basis to believe that Mr. Case might be inside, seriously injured or in imminent danger of harming himself. Now let's talk about what this means for all 50 states because the implications here are massive and far-reaching. With this decision, the Supreme Court has effectively wiped out the reasonable suspicion shortcut that many states were using. This creates a uniform national standard. Before this decision, you had different standards being applied in different parts of the country. Some federal circuits were more protective of Fourth Amendment rights, some were less protective. Now, every state, every jurisdiction in America has to apply the same standard. This means your Fourth Amendment protections are now standardized regardless of whether you live in California or Texas, New York or Florida, a rural area or an urban area. In California, which generally has strong privacy protections, police departments will now need to ensure their policies align with this Supreme Court standard. If someone calls about a welfare check on a person in Los Angeles, the officers responding need to evaluate whether they have an objectively reasonable basis, not just a hunch or a vague concern. In Texas, where there might be more firearms in homes statistically, this ruling clarifies that the mere presence of a gun or a holster isn't enough by itself. Officers need more facts, more context that indicates an actual emergency. In New York, in places with dense populations where wellness checks are common, this provides clear guidance on when officers can enter apartments without warrants. In Florida, in retirement communities where wellness checks on elderly residents are frequent, officers now have clear standards to follow. This is where the implications get very real for gun owners and civil liberties advocates. In the concurrences, specifically from Justice Sonia Sotomayor, the court touched on a nerve, the intersection of mental health and police entry. For states with red flag laws or those that frequently use community caretaking as a justification for seizing firearms, this ruling creates a specific framework. It means that while the police can enter if they think you are in danger, they cannot use that entry as a pretext to start rummaging through your drawers or looking for evidence of other crimes. One of the biggest fears surrounding this case was that emergency aid would become a Trojan horse for seizing firearms. If the police enter your home because they claim you are suicidal, does that give them the right to seize your weapon? The Supreme Court provided a very specific guardrail here. The ruling emphasizes that the scope of the search is strictly limited to the emergency at hand. If they enter to see if you've been shot, they cannot start opening drawers to look for unregistered parts or non-compliant magazines. However, there's a legal reality we need to discuss, the plain view doctrine. Under the Fourth Amendment, there is a long-standing rule. If the police are legally in a place they have a right to be, like your living room during an emergency, and they see something incriminating in plain view, they can seize it without a second warrant. In this case, once the officers entered Mr. Case's home to check on his well-being, they found a handgun in a laundry basket. Because they were reasonably in the room to prevent a suicide, the seizure of that firearm was upheld. This is the plain view trap. Even if the police enter for a non-criminal reason, like a welfare check, anything they see while performing that check is fair game. This means the safe room is no longer safe. If you have firearms, sensitive documents, or anything else you consider private, the moment a well-being check is triggered by a 911 call from a disgruntled ex-partner or a concerned neighbor, those items are potentially subject to government observation and seizure. The court was very clear that police cannot go exploring. They can't look in your medicine cabinet to see if you're suicidal. but they can look anywhere a human body might be. If they are looking for you, they can look in your closets, under your bed, and in your basement. Anything they see along the way is no longer private. This 9-0 decision also creates a massive ripple effect for qualified immunity. For those who don't know, qualified immunity is the legal shield that protects officers from being sued personally unless they violate a clearly established right. By clarifying that reasonable suspicion is not the standard for home entries, the Supreme Court has clearly established the law. This means that going forward, if an officer enters a home based on a mere suspicion rather than an objectively reasonable emergency, they can no longer claim they didn't know the law. They are now on notice. The "I was just doing a welfare check" excuse has just become much harder to use in a civil rights lawsuit. One of the most chilling parts of this case, and something Justice Sotomayor hit on in her concurrence, is the idea that the police entry itself often creates the danger. In the case instance, the man was in a closet. He wasn't hurting anyone. It was only when the police entered his bedroom and startled him that shots were fired. This leads us to a critical question that the court left hanging. If the police entry is what causes the violence, can that entry still be considered reasonable? Sotomayor pointed out that individuals in a mental health crisis are 7 times more likely to be killed during a police interaction. So how do you protect yourself in a post-case versus Montana world? The Supreme Court has given us the rules, and now we have to play the game defensively. The court's decision emphasizes that the entry must be based on objective facts. This means that if you are ever in a situation where police are at your door for a welfare check, your conduct and the information provided by third parties are being weighed on a reasonableness scale in real time. One of the most powerful tools we have now is documentation. Because the standard is objective reasonableness, the police must be able to point to specific facts. In the case, those facts were a specific threat of self-harm reported by a witness, a history of mental health interactions known to the officers, an empty holster visible through a window, and silence from within the home for 40 minutes. If those facts aren't there, if there is no holster, no history, and no silence, the entry becomes unreasonable. This 9-0 ruling actually gives us a checklist to hold police accountable. If they enter without those types of objective markers, the response is to challenge that entry in court immediately, using this very 9-0 precedent as a shield. As we wrap up this deep dive, we have to ask, is this a win for the people? On one hand, yes. The Supreme Court unanimously slapped down the reasonable suspicion standard. They told the lower courts that they cannot treat your home like a street corner. They reaffirmed that the physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed. By forcing police to meet the objectively reasonable bar, they have made it harder for officers to just check things out on a whim. On the other hand, this is a sober warning. By affirming that police do not need a warrant or even probable cause of a crime to enter during a mental health crisis, the court has codified the caretaking role of the state. In a country where red flag laws are expanding, the definition of what is objectively reasonable will be the next great legal battleground. This decision impacts pending cases in every state. Right now, across America, there are probably hundreds, maybe thousands of cases pending in courts where defendants are arguing that police unlawfully entered their homes under emergency aid exceptions. All of those cases will now be evaluated under this clarified standard. This 9-0 decision is a landmark because it brings uniformity to all 50 states. No matter where you live, the standard is now set. The government has been given a narrow path into your home without a warrant, but it is a path that we can now monitor and challenge using the court's own words. This case proves why it is so important to understand the law. Law enforcement knows the law, the prosecutors know the law. If you don't know the law, you are at a permanent disadvantage. You need to know where the line is drawn so you know exactly when the government has crossed it. If you found this deep dive helpful and you want to keep your legal toolkit sharp, make sure to like, comment, and subscribe. Tell me in the comments. Do you think the objectively reasonable standard is enough to protect your home, or should the court have required probable cause even in emergencies? I want to hear your thoughts as it helps fuel the algorithm and spreads this critical information to more people who need to understand their rights. Thank you for your support, and never forget to like, share, and subscribe.